Good afternoon. The Commission on Cannabis Oversight will come to order, and I'll ask the clerk to please call the roll.
Senator McClellan, Senator McDougall, Senator McPike.
Here.
Delegate Adams.
Here.
Delegate Campbell. Delegate Krizik.
Here.
Delegate Moorfield. Delegate Scott.
Here.
Delegate Herring.
Here.
Senator Eben.
Here.
Mr. Chair, you have a quorum.
Great. And I think that you said that we're expecting Senator McDougall to join us via Zoom.
Yes, I actually don't think he's going to be able to make the meeting.
Okay. And I heard from Delegate Moorfield is just pulling in the garage. He'll be joining us in just a moment. So we have a few things on our agenda today to oversee the implementation of our new cannabis law and potential reenactment of a large portion of that for the next session to discuss it. I understand that Megan Field from the Governor's Office is here with us today to report on how the new Cannabis Control Authority is taking shape thus far. Welcome, Ms. Field.
Thank you. Thank you for the invitation. My name is Megan Field, as you all know. I'm a policy advisor to Governor Northam on agriculture and public safety, which includes cannabis. And I'm here to share an update on the standing up of the Cannabis Control Authority. So as you all are aware, the Cannabis Control Authority is led by a 5-person board of directors. At your last meeting, we were excited to share the biographies of the governor's appointments to that board. It's a really impressive board who has already met twice. That first meeting was on September 9th. The primary purpose of that meeting was to orient the board to its statutory powers and obligations. So as you all know, and as Mr. May knows, this is a massive piece of legislation, and we wanted to make sure that the board had a very clear understanding of the law, but also of its obligations under FOIA and COIA around transparency and ethics. We know there's a lot of public interest, and there are actually additional ethical obligations for this board. So that training started with Secretary Moran welcoming the board and laying out the landscape of where the Cannabis Control Authority fits into the state structure of government. Secretary Moran stayed for the remainder of the meeting to advise the board, to share his experience with leading ABC and with other startup ventures. Afterward, Assistant Attorney General Jim Flaherty from the Attorney General's office gave the board training on ethics, transparency, and obligations. Mr. Flaherty is counsel to the board and is in touch with the board and is providing advice. Finally, Assistant Secretary of Public Safety Jacqueline Catoon and I briefed the board on the Cannabis Control Act itself with a focus on the structure of the authority. We spent a lot of time laying out the two main responsibilities of the board, which are oversight of the CCA's operations and eventually setting and enforcing regulations around the cannabis commercial market. So on that first topic, oversight of the CCA's operations, the board took important first steps at its next meeting, which was last week on October 8th. Since the authority is in its, what we're calling a startup phase, it has the responsibility of approving foundational policies and processes and creating the first ever comprehensive budgets for the authority. So Secretary Moran's team, including Deputy Secretary Talmadge, who will be reporting next, has been supporting and advising the CCA's board as it works to build that foundation. There's been an incredible amount of collaboration with other state agencies to put together that comprehensive budget to start providing options to the CCA's board as it starts making decisions. So that includes locating potential office space, coordinating to establish financial functionalities. We've had the joy of working with the IRS, which I've learned a lot from, establishing payroll, retirement, other benefits for employees, providing options to the board around furniture, IT, other equipment, and providing strategic guidance on long-term planning so that the board doesn't make quick decisions which are more expensive than they need to be if they took a little more time to really think through the long-term needs. So just to dig into that a little more, at that October 8th meeting, the Cannabis Control Authority's board laid the groundwork to begin hiring staff for the CCA. By statute, the board has to approve human resources policies that ensure that hiring is done in a fair, equitable, and non-discriminatory manner, that employees have grievance rights, and that state and federal law is followed in a plethora of manners. So the board chose to adopt the Department of Human Resource Management's model policies on an interim basis. That'll give it a framework to get its first staff in the door, and then as it has human resources staff who has capacity, they can take a closer look and re-examine whether there are places that down the road the CCA might want to have more flexible or competitive human resources policies to be able to compete with the private sector to attract top talent. The board also discussed its priorities for hiring. So as you know, at this point, the CCA doesn't have any employees, but the board, after adoption of these policies and discussion of its priorities, is set up to start hiring soon. So the chair started out by emphasizing how important it was to him and to his colleagues to make sure that the hiring is done in a way that individuals who don't normally apply for state government jobs hear about the opportunities, feel welcomed and encouraged to apply. And that includes making sure that screening criteria isn't thoughtlessly adopting biases that may exist in other state government processes. That also means doing proactive outreach, maybe beyond what's normally done for a state agency. The board also emphasized that it would like to do proactive recruiting, especially in the hiring of its first C-suite level individuals, to try to attract talent to Virginia, to state government, to make sure that the ambitious goals of this legislation can be met. So as I described earlier, the board approved a process for approving job descriptions, reviewing the applications that come in, and then actually making hiring decisions. They are coordinating with the Secretary of Public Safety's office to support those efforts, and they hope to have the first job openings posted in the coming weeks. That'll include 2 statutorily mandated positions. The first is the Cannabis Social Equity Liaison, which, if you all recall, this person has both internal and external responsibilities. Internally, they're there to provide guidance to make sure that the Cannabis Control Authorities is built in a way that respects diversity, equity, and inclusion, including making reference to Dr. Underwood's One Virginia work, and externally to make sure that Virginians of all backgrounds are aware of and have access to opportunities in this market. The second statutorily mandated position is a Public Health Advisory Council staffer. This is someone with a public health background who will serve as a staff member to the Public Health Advisory Council. So the CCA has plans for hiring positions soon, including those 2 statutorily mandated positions. The board also approved an operating budget for fiscal year 22, the fiscal year we're currently in. As you all remember, $3.5 million was included in the general fund for the CCA to begin operations. The Secretary of Finance, in consultation with the Director of Diversity, Equity, and Inclusion, must approve any disbursements from the general fund to the CCA. So Secretary Moran's team has been working closely with Secretary Flores and Dr. Underwood, as well as with sister state agencies like DHRM, DGS, and others, to develop a comprehensive operating budget for the CCA for this fiscal year. That budget contemplates salaries for about 20 employees. Of course, we're some months into it, so the budget also reflects the fact that it would be salaries for part of a year rather than a full year. It also includes funding for office space, equipment, IT, and other needed services. The total comes to about $2.3 million, which reflects the fact that we're some months into it, but also leaves room for the CSA to adapt depending on what happens with reenactment. The board also approved a budget request for fiscal years 23 and 24. The executive branch is in the process of developing the governor's outgoing budget. Before I dive into the specifics of what's in that budget request, I want to just highlight the unique situation the CCA is in, given the uncertainty of reenactment. The authority will have to work closely with you all, with money committee staff, with whoever the next governor is to adapt the submitted budget request as reenactment progresses and its obligations may change. But now to the specifics of what has been contemplated as the bill is currently written. So the authority's request was publicly submitted to DPB, and it's in the stage of being reviewed by the Department of Planning and Budget before it goes to the governor's office for consideration in his outgoing budget. The CCDA predicts it'll need about 12.1 million in fiscal year 23. That would be enough to expand the number of employees to about 70, with a particular focus on hiring staff for the business equity team and the policy department, which would be writing regulations. There's going to be a lot of front-loaded work for those two departments, given JLARC's recommendation and what we've heard from other states that social equity goals need to occur on the front end to ensure success. And of course, everyone's aware of the long list of regulations that need to be written. So there's a focus on the business equity team and the policy regulatory departments. The authority predicts it'll need about 21.9 million for fiscal year 24. That gives it the resources to grow to about 115 employees. As you'll recall, JLARC estimated a mature agency would need something like 110 to 140 employees. So again, this may have to change depending on what mandates it gets after reenactment, but that's for about 115 employees. It's also for public health and social equity outreach campaigns. There's a mandate around safe driving, around youth prevention, but also proactive outreach to diverse communities, to communities that have been historically over-policed and underinvested in, to encourage diverse ownership in the industry. And of course, everyone's favorite topic, enough resources to begin processing and issuing business licenses. I want to highlight just two things really quickly. One is that also includes $6 million for the Equity Loan Fund, which as currently written is contemplated to go to social equity qualified applicants to help address the problem of access to capital. It also is important to note that in fiscal year 24, the CCA should begin to start receiving some revenue from license fees, which are indeterminate at this point, and also potentially for taxes, depending on how the tax structure is set up. I want to pause briefly on tax revenues just to highlight the fact that the tax revenues are currently dedicated to three important buckets: public health, including substance abuse prevention and treatment, the Cannabis Equity Reinvestment Fund, which is being managed by a separate board from the CCA and is designed to bring investment to communities that have been underinvested in historically. And lastly, pre-K for at-risk 3 and 4-year-olds. Thanks to the investments over the last couple of years, Virginia this fall saw historic enrollment in its preschool programs. We're coming out of a deficit in the area of early childcare, and we've made just tremendous strides in getting 3 and 4-year-olds into quality programs. And the governor and first lady are just tremendously proud of the investments that you all have supported and the metrics that we've seen this fall, and look forward to continuing to see that grow with these investments when they occur down the road. So as I mentioned, the CCA's budget request is currently moving through the executive branch process. We look forward to sharing specifics in December when the governor's budget comes out. I also just want to share a brief update on the other two cannabis boards. The Cannabis Equity Reinvestment Board as I was describing, will receive 30% of the tax profits, which will be used directly to address the impact of economic disinvestment and disproportionate enforcement of drug laws in certain communities. That board is having its first meeting next week, October 19th. It will be in the Patrick Henry Building. Dr. Underwood's team has put together a really impressive day-long agenda, which can be found on the Commonwealth calendar. And that community-driven board, there's a lot of energy and a lot of work has already gone into making sure that by the time it has those funds, it'll be well set up to make sure they're spent wisely. Similarly, the Cannabis Public Health Advisory Council, which you'll recall is an advisory council to the CCA's board, it also has to approve any health-related regulations. It is having its first meeting on October 28th from 10 to 12:30, also in the Patrick Henry Building, also open to the public. Secretary Carey's team will be sharing more information on the agenda soon. It'll be some work, the typical ethics and transparency obligation, and also digging into some first questions around public health and cannabis. In the coming weeks, the CCA will be focused on continuing to grow its capacity. The behind-the-scenes work we expect to blossom publicly around hiring, around getting them into office space, and bringing that staff on to really amplify the work they're able to do. The board will meet at least once more this year, and potentially 2 or 3 times more. And we look forward to supporting the CCA's growth and also to serving as a resource to you in whatever ways you need.
Thank you. Thank you, Ms. Field, for the report. I have a few questions before I ask the committee if there are others who have questions as well. You mentioned that the job descriptions were being developed for some of the first hires, but thus far there are no positions yet hired exclusively for the CCA. Is that right?
That's right.
Okay.
Yep.
When can we expect some of the C-suite leaders or the executive director or acting executive director to be in place? Is there a tentative time frame on that?
The search for the CEO is ongoing. It's a difficult job, and the governor thinks it's really important to make sure we have the right person in that position. So that search is ongoing. The board has started to contemplate job descriptions for other C-suite staff, including that business equity liaison, a chief administrative officer to manage human resources, finances, and procurement, and also a policy director who would do policy communications, that space. Those job descriptions have been developed and are being considered by the CCA board at this point. So it's possible, next couple of weeks, depending on how much change the board would like before they're published.
Great. I would just really encourage, I know it's a challenging thing to recruit a CEO, particularly if there's any uncertainty on their part about what might be happening in the future, but to consider even hiring an interim CEO if it looks like the search is going to be a prolonged one, someone perhaps experienced in state government who might help the agency get set up. But I'm pleased to hear that you're being proactive in filling some of these positions. So I assume we can't start discussing regulation until we hire the policy officer. I mean, the CCA can't discuss that internally, and I guess that's one of the priorities for early hires?
Yes, yeah,
Okay.
absolutely, absolutely. And the board does have on its agenda for this year to educational work. They want to start bringing in experts to start getting the foundations for the policy work, but that's why they've prioritized a policy director hire soon.
Okay, well, we look forward to the progress that will be made. Are there members of the subcommittee who have questions for Ms. Fields? Are there any other questions today? Okay.
A quick question. I
Delegate
know
Krizak.
I can look this up, but since you're here, the Cannabis Equity Reinvestment Board. Thank you, Mr. Chairman. Cannabis Equity Reinvestment Board. Is that a policy board?
It'll develop the criteria for how to distribute the funds. There are, within the legislation, there are specific categories of how the funds can be spent around scholarships for people who've been disadvantaged by substance abuse, for grants, for workforce development, reentry programs, mentorship programs. So the code has broad categories, but this board will have to figure out the particulars of exactly what the process is and what those programs really look like.
Thank you, Mr. Chairman.
I should mention that we've been joined by Delegate Will Moorfield and Senator Jennifer McClellan, so thank you for joining us. Okay. Well, thanks for the good work, and please feel free to connect with me in the interim if there's more updates on the pace of staffing up. But glad to hear the administration is focused. Now we have a report from Sean Talmadge, Deputy Secretary of Public Safety, on the status of ceilings and expungement. Welcome.
Thank you, Mr. Chair, Madam Vice Chair, members of the Commission. I am Sean Talmadge, Deputy Secretary of Public Safety and Homeland Security. I'm also the Governor's Homeland Security Advisor, and I'm the liaison to the Virginia State Police, the Department of Emergency Management, Fire Programs. Also in the portfolio is the Homeland Security Policy issues. So you can imagine it's been an unprecedented couple years, but it's so great to be here in person, standing in front of a microphone instead of the TV or a computer. So it's great to be here. And of course, Secretary Moran is traveling today. He sends his regards to the entire commission. He has some well-deserved time off up in New England. So today I have basically two updates regarding marijuana-related record sealing, and then a quick update on the strategic change where we're kind of shifting our efforts to automatic sealing and expungements. So consider the temporary record sealing in the marijuana bill as one piece, and then the second piece is, Virginia needs that dynamic, contemporary, modern criminal justice database system, which, thank you to many of the work here, commission members, provided the state police sufficient funds to make that a reality. And I'm looking forward to that because, moving forward, as we consider other criminal justice reform activities, it'll be so much more simple, and the cost will be negligible or little compared to a variety of activities that would be required with our legacy system. So, as you're aware, back in 2020, in July of that year, with regards to decriminalization of marijuana, early in that month, the Virginia State Police sealed 333,806 records involving simple possession. And then, of course, fast forwarding to the legalization of marijuana, in the early morning hours of July the 1st, the team at State Police came into work, and fingers crossed, the program actually worked. Again, this is a legacy, almost like an MS-DOS type language, and the good news is that program executed without any errors, and a number of records were sealed. In the database, 64,651 charges of misdemeanor distribution. That would be under 18.2-248.1, so that's misdemeanor charges there. And then the second, just under 400,000 entries that were less serious offenses. And those include all offenses under 18.2-250.1. And those are charges, convictions, and dismissals. So any record under that section of the code were deleted and removed from the database. And then moving on to my second portion of the report, the great news is with the funding that was sent to the state police, even before that bill was enacted, they were forming a working group to begin this interagency process. If you recall, this database does serve as the backbone of the entire criminal justice system, but DMV is a participant, the courts is a participant. So that working group already jump-started in that process to design the requirement, appointing a program manager, getting the working group members together, and a number of procurement actions have already begun to occur. RFIs for requests for information, requests for proposals, and the like. So I'm really happy to report that the state police is owning this process and is moving forward very quickly. And I share no concerns in terms of getting this database up and running. Now, given the complexities there, I'm sure there's a, hey, Sean, is there a way that we can speed up this process? That would be very difficult to do. That would probably incur additional costs. But remember, we've got to make sure the connection between all these different databases are created correctly the first time. Otherwise, we're going to have cost overruns, project overruns, and that's not what we want. So I would ask to please be patient. We will absolutely, we'd be happy to provide regular routine updates. And if we have any concerns or issues, we're off track, we'll definitely work with you to provide an update, what's going on and what we may need to help address those issues. But as of right now, the process is proceeding with no issues.
Thank you. If I might interrupt with one question. The simple possession records that were sealed, the misdemeanor distribution records that were sealed, and I think you said the 18.2-250.1 were deleted. If the Cannabis Control Authority wanted to access any of those sealed or deleted records exclusively for the purpose of ascertaining that someone qualified for, say, an equity license, would they be able to do that if we allowed that under the statute?
If you allowed under the statute, yes, because these are, well, for the first portion, the -248.1 misdemeanor distribution, those records are sealed. So the records still exist, but only for only certain purposes, and certain folks can obtain access to that. So if they demonstrate that in accordance with the bill or the law, then they will be able to review those records. Now, the second, just to clarify, the second 395,747 entries, these were less serious. These are charges under 250.1 that you referenced, Mr. Chair. Those records, in accordance with the bill, were deleted. So there are no more records of any charges, convictions, dismissals under 250.1 in accordance with the law.
So if someone had a deferred disposition for cannabis possession in the past, the only way that they would be able to prove that if they were an equity applicant, if indeed that qualified them, would be to have their own records.
Right, and if you have the authority to access those sealed records, that's correct.
Okay,
Mr.
but even
Chair.
the 397,000, were those deleted or sealed?
Those are deleted under
Okay.
250.1.
So really then the only way to, if you were one of those people, to show that you had undergone that experience would be from your own, preserving your own court records?
Yes, Mr. Chair, I understand the question now, precisely.
Okay. Are there, was there more to your report, or was that?
There is not. I try to keep things short and sweet.
We appreciate that. Thank you. Was someone waiting to be recognized?
I just quickly,
Hearing.
just thank you and thank the state police for moving so quickly. This is something that, no surprise to anybody, has been a passion of mine, this automatic
Yes, ma'am.
expungement, and where Virginians don't have to pay attorneys. I'm an attorney, but, and go through that traumatic process of appearing in court. And so I just want to thank you and everyone who is involved for the work. It's meaningful. Thank you.
I'll be sure to pass that on to Colonel Suttle. Thanks for having me today, and please reach out if there's anything we can do.
Thank you. Thank you to your
Thank you,
entire
Mr. Chair.
team. We now have a presentation from Gracie Berger, who's the State Policy Director from the Last Prisoner Project, about resentencing policies in other states or potential resentencing policies. Is she on the Zoom?
I am. Can you all hear me?
We can hear you fine, Ms. Berger. You have the floor.
Thank you. I'm going to share my screen. All right. Let me just make this bigger. Is everyone able to see my screen?
We can see your screen.
Thank you. Thank you, Chairman. And thank you so much to the whole commission for having us here today. I am actually a Virginian. I am zooming in from where I live in Boston, but I am actually born and raised in Virginia in a tiny town in Gloucester County called Ware Neck. So I cannot tell you how pleased I am to have been invited to share information about resentencing in my home state today, especially because of the progress that has been made in the Commonwealth over the past year or so, especially in the last session. due to the leadership of the members of this body and the rest of the legislature. Being the first state in the South to end prohibition is truly historic. And especially, the members of this commission, Leader Herring, especially the leadership on automatic expungement has just been incredible. So thank you so much to the body for having us here today. Like I said, my name is Gracie Berger. I am the state policy director for the Last Prisoner Project. And we are a national nonpartisan nonprofit focused at the intersection of criminal justice and cannabis reform. So we do both direct services and policy work. So we have incarcerated clients and clients who are reentering society all around the country, including in Virginia. And we provide legal and reentry services for those individuals. We also provide data-driven policy expertise from our work in jurisdictions around the country at the local, state, and federal level. And that is the work that I'll be speaking to you about today. And our mission is simple. There are at least 40,000 individuals across the country, according to federal BJS data, that are serving sentences related to cannabis behavior. And our mission is to achieve full freedom for those individuals in light of the move toward legalization at the state level around the country. I'm going to pass the screen to Chelsea Higgs-Wise next.
Hello, thank you so much to the commission, the chairman. My name is Chelsea Higgs-Wise, and I'm the executive director of Marijuana Justice. And we're a Black-led organization that's been around for a couple of years and really supporting the equitable legalization right here in the Commonwealth. And we are so proud of what's happened in the Commonwealth and the measures that we've taken right here. And we're also really proud to be leading the state with the Legalize It Right coalition that's focusing on the repeal of the prohibition, as well as redressing the ongoing harms inflicted by the war on drugs. And we're excited to mention just a couple of our partners that you may also know: Virginia Student Power Network, Rise for Youth, and Justice Forward. So we're really committed to supporting resentencing as well as reparations for people with marijuana convictions, for our continued legalization that centers equity. And we truly know that we cannot move forward without it, and why we are really excited to have brought in the Last Prisoner Project to our national partners to talk with this commission and really support you all as you take a real look for this process of resentencing. So as I mentioned, that Marijuana Justice has partnered with LPP, and Gracie has been so amazing working with us in the last few weeks. And she'll be going over some technical pieces here that you see in the agenda. So that will be the policy overview, the model policy components, the national context, the Virginia local context, as well as policy recommendations. All right, so we're really going to just start understanding, and I think we all know after such a long process, as Ms. Fields mentioned, this very robust bill, that last session, Virginia made history as the first Southern state to repeal the marijuana prohibition for simple possession. But despite that tremendous progress, there are still people incarcerated in the Commonwealth for cannabis-related sentences handed down during this prohibition. So the goal is to provide a process for cannabis-related sentences to be reconsidered and for appropriate individuals to be resentenced and released in light of legalization and our Commonwealth's priorities for equity. This will align our criminal justice practices with the acknowledgements that the Commonwealth has made that prohibition was a failed public policy and promote access to justice here in the Commonwealth.
Thanks, Chelsea. So when we're talking about effectuating release for individuals that are under the custody of the state, there's really three policy options that we're talking about in most states, not just in Virginia. There's executive clemency, which is, of course, up to the decision and the discretion of the executive office holder. There's parole, which of course is limited there's not discretionary parole in Virginia. So, in most states, this is a bit more robust in terms of individuals who are released on supervision. And then there's resentencing, which is the focus of our conversation today. And it's really the recommended approach from our experience working on policy around the country, as well as working with our individual clients. We really believe that the statutory framework to allow the courts to reconsider sentences that they've handed down in the past in light of changing cultural attitudes, in light of statutory changes, is really the gold standard to effectuate release for individuals from incarceration, because it standardizes a lot of things. We don't want to be creating a system where we're seeing justice by geography, where someone in my hometown of Gloucester County is getting access to relief that is different from an individual in Loudoun County, right? So we really want to see a statutory framework that's providing standardization in its eligibility. So who the state agrees is eligible for being considered for a certain type of relief. Standardization in the process. So it's moving through the system in the same way, regardless of where you are and what type of stakeholders are working on that case, and the outcomes, right? So again, if there's a statutory framework that provides guidance for how these sentences should be reconsidered and then decided upon by the court, you'll see more standardization and outcomes as far as who's released and who's kept incarcerated. So just, I think everyone on this commission is pretty familiar, but just to clarify, when we're talking about resentencing, there are a couple synonyms out there, one of which is actually in Virginia's statute already. Sentence reconsideration, we're talking about the same thing. Sentence modification, we're just talking about the process through which a court is given the authority to, and in some cases incentivized or encouraged to go back in and look at certain sentences that they've handed down and to consider issuing a new sentence, some of which might result in release. So an example of that is a new sentence to time served, which would effectuate immediate release or discharge from supervision. So we were asked to speak on model policy components today. These for resentencing, these models are, these policy components are based off of our work around the country. We work with a whole network of attorneys and legislators and implementers of policy. And so these policy components are really formed from the basis of statutory research on state frameworks for not just cannabis, but for criminal code in general, for how states can reconsider certain sentences. So some cases where we've seen this in the past, and I believe also actually in Virginia's recent past, as a result of a Supreme Court decision several years ago, most states had to reconsider sentences for individuals who were sentenced as juveniles to life without parole. Another example of this is when states repeal mandatory minimums or certain drug sentences and are then encouraged or go back in and adopt resentencing. So the first model policy component to talk about is the eligibility scheme. Who is eligible for either asking for this relief or receiving this relief? And there's really three core components to the strongest eligibility scheme. We want it to be clear so that the people charged with implementing a resentencing process, so that there's not room for misinterpretation, right? So it's clearly enumerated in the statute which offense codes or which case types, so a description of the types of factors that might be considered, or specific enumerations of the offense codes that can actually be queried by the stakeholders who are charged with implementation. So having something clear in the statute is really important. If there's something broad, like marijuana related, that can be misinterpreted, and it also can't be easily automated because you can't type in marijuana into an automated system or pull it from a dropdown in, say, DOC or the court's database. You need those specific offense codes to look for. We'd also encourage a broad scheme. So even though states all address their legalization programs differently and contemplate different ways to change their criminal code as the result of repealing their prohibition, There are, of course, offenses related to cannabis that are still considered illegal post the passage of legalization. But the passage of legalization is significant, right? Because it represents a real shift in cultural attitudes of the public of that state and how that state should be considering how marijuana in the past was enforced, prosecuted, and sentenced. So we encourage a broad eligibility scheme that is not limited to just those individuals sentenced to and serving sentences that are now erroneous under the repeal of prohibition, but broader to include individuals serving sentences related to cannabis activity. And of course, that's different based on every state's practices around enforcement and prosecution. The third component of the eligibility scheme that we encourage, and I'll talk a bit about, more about this later in the presentation, but it's a tiered scheme. So if you think about the lowest hanging fruit on a tree, that's this top box, those individuals who remain incarcerated solely for marijuana-related convictions, some of which may now be legal in a state. So something like possession or possession with intent to distribute. And we recommend that that first tier be responded to differently, that they have the lowest barrier for entry to be resentenced and ultimately released. So you could contemplate something like automatic modification of that sentence to time served and actually waive the hearings to really, promote automation, promote a streamlined process, and actually reduce the cost to the state, the burden on the state to docket those hearings and to consider those cases. The second tier that we recommend is for those individuals who remain incarcerated solely due to an enhancement as the result of an ancillary, so another charge on their current case, or a prior marijuana related offense. And so we encourage the state to consider perhaps giving the option of the court to have hearings, maybe not mandating those hearings, but the option to consider those cases and give the judge discretion to consider the factors of those cases, but to institute a strong presumption that the sentence be modified to something like time served to effectuate release. And for this third tier, and there actually could be a couple more that we could add on, but I won't go too into the weeds today. For the third tier, it's those individuals who remain incarcerated on marijuana-related charges or enhancements, but they're those higher level cases and they're attached to something that isn't related to marijuana. We see a lot of our clients have felony firearm or other weapons charges or other controlled substance charges attached to their case. And we believe that those individuals should still have the opportunity for the court to consider in light of legalization, would they have handed down that same sentence? But we understand that the court would want to consider those factors in an individual manner. So the next component of a strong resentencing program is the state identification of candidates. And I think that this is something that this body is familiar with, having dealt with the really, really impressive program of automatic expungement that Virginia is instituting. I've worked on automatic expungement for several years in many states around the country. And I really want to commend Virginia, and Sean has done wonderful work on really communicating out how much progress Virginia has made on specifically marijuana automatic expungement. The justification for automatic is really founded in a broad body of research that shows when there's the barrier for the individual to know that they're eligible for a certain type of relief, in this case, resentencing, but for expungement, I know that you were all part of these conversations last year. Impact is really limited. The individual has to know that they're eligible. They have to know how to navigate a really complex legal system. In a lot of cases, for expungement, in all cases for resentencing, they have to know how to find counsel and to pay for counsel for themselves. So there's a ton of barriers to actually getting this process kicked off. And that's why we really recommend that the state trigger this process. The state has the data, has access to the databases through DOC and the courts to identify individuals who are eligible for relief. And then the state has the power to trigger that process, to start docketing those hearings, to start providing counsel and that sort of thing. I don't have data on this because I don't work specifically in Virginia, but I have heard anecdotally from practitioners in the state that in the past, when limited programs of resentencing have been have happened in Virginia as the result of just very limited changes in law. Individuals did not know that they were eligible. And so the impact of those programs, according to these practitioners, were quite limited. And that's something that I would definitely encourage this body or whatever body is vetting this sort of policy to look into to see, how to troubleshoot those barriers. The next model policy component is to provide in the statutory language clear guidance and limited discretion. So this is a problem that we see every day in our work when we're supporting government actors in the implementation of both automatic expungement and resentencing. It's that the statute was written so broadly that the actors charged with implementing it really have no guidance on how the legislature wanted them to use that statute, to exercise it, to effectuate relief or not. And so really providing clear standards for, namely the judiciary in the statute, especially around how the process should unfold, who should receive hearings, what should be considered in the hearing, what material shouldn't be considered, how each component should be weighed, and how the court is expected to come down, really instituting explicit presumptions of relief so that the court knows this is what we need to consider, this is what we don't need to consider, and barring any other enumerated issues, we should come down on the side of a sentence modification and perhaps one to time served to effectuate relief. And we would also encourage that the statute limit stakeholder discretion. This prevents, this allows automation and a more streamlined process. And it really, is in line with ensuring the spirit of a policy whose goal is to effectuate release of individuals that are determined appropriate, within public safety standards, and to really ensure that relief is found. The next policy component that we recommend is proactive provision of counsel. So we see in a lot of cases that counsel is not actually provided at all for these individuals. So they either can't afford it, don't know how to navigate how to get counsel, that sort of thing. That's a barrier. But also in some cases when counsel is provided to individuals or as an option, there's the path toward that is also covered with barriers because the individual in some cases has to do multiple different filing processes just to prove that they are indigent to get that counsel, to get access to that counsel. So for these specific cannabis resentencing situations of which, the number is not going to be overwhelming in most cases, we really encourage that counsel be provided to those individuals to move this process forward. The next component is to provide enforceable and explicit timelines for all of the stakeholders who are charged with implementation of a limited resentencing process around cannabis. This is, I would say, one of the most glaring gaps in the places where we've worked on implementation of both automatic expungement and resentencing. The process was laid out and timelines weren't applied. And so the process doesn't play out. And unfortunately, there's often games of, pointing at who was supposed to move the process forward and things just kind of stall. And so individuals are eligible for relief, but they're not actually able to access it because stakeholders and state agencies aren't clear on when they have to do certain things. So we really encourage around each of these junctures of the process that there be timelines that are clear in the statute, meetable, of course, they should be in line with resources that are available to the state, but that they're enforceable, that they can be met and are met to provide justice for these individuals. And the last component is oversight and reporting. This is a big one, and I believe that Virginia in the past around several reforms in the criminal code has provided reporting to the legislature on certain performance metrics, and that's great. And we would recommend that in this case, that an existing body or a new one is created and vested with the power to monitor the process, to make sure the timelines are met, that the pieces are moving forward, and to report back how the process is going, to troubleshoot any issues, to answer questions for all the stakeholders that are involved with implementation, and to share with the public how that process is going. Real specific data metrics. How many individuals have been docketed for hearings? How many individuals have been resentenced? How many individuals have been released or discharged from supervision? So we wanted to share some national context from our work around the country. There are three main types of resentencing that we see, again, not specific to cannabis, but this is a really growing space in the legal reform space, cannabis-specific resentencing, because of the momentum behind legalization in the country. But that's not the only type of resentencing there is, of course. So on this slide, at least, these two states are focused on cannabis resentencing, but petitioner-initiated resentencing. So again, not the gold standard that we would recommend, because it requires that the individual have to know that they're eligible, have to know how to initiate the process and then push the process forward. But just in the past year or so, both New York and Montana legalized marijuana through different mechanisms. New York through legalization, Montana through a ballot initiative. And they both allowed individuals who are deemed eligible to petition the court to be resentenced. And so the great part about both of these measures is that both Montana and New York included language that provided a strong presumption for the court to grant the petition. And they included enumerated reasons for why the court might not. It's a rebuttable presumption. The court still has discretion, but it does institute that guidance that barring these few reasons, we do expect the petition to be granted. The other type of resentencing that we see, and really in just the past 2 years, we've seen really growing steam around the country, is prosecutor-initiated resentencing. We would recommend that a resentencing program never be limited to only prosecutor-initiated, that an individual should still always have the option. But in California and Illinois in the past couple of years, not related to cannabis, not related to legalization efforts, but in separate criminal code reform efforts, both of these states passed legislation to allow the state's attorney, the DA, or the prosecutor to initiate a resentencing petition on the defendant's behalf to ask the court to reconsider a sentence. And both of these pieces of legislation did include some level of guidance to the prosecution about who they should consider as eligible and how they should come down in terms of the outcome, but it was really limited. And in the case of California, it was actually founded around a pilot program that vested the authority, the entire authority, to determine the eligibility scheme up to the county that opted in to this resentencing program. So it's, of course, progress. It's better than nothing. But we'd still encourage really clear guidance for how these resentencing programs should come down. The third and last type of resentencing, again, is that gold standard, automatic, meaning that the state initiates the process, and especially in light of the state acknowledging the failed public policy of prohibition and really taking that on. It makes sense, especially because the state holds these data sets to really initiate these processes. And so New Mexico and Washington, New Mexico with their legalization legislation and Washington separate from that, they both have automatic resentencing provisions that provide for the state to actually be compelled to identify these individuals and initiate the resentencing process for those individuals that are deemed appropriate. So some context about Virginia that we can provide. I mentioned in the beginning that we are both a direct services organization and a policy organization. And I wanted to share the story of Brian Reed. This is a client of ours who is currently incarcerated in Virginia, in Coffeewood. And Brian has 4 children. He is incarcerated for possession with intent to distribute 13 pounds of marijuana. He did have a valid medical card, and he has no history of violence. He does have priors. They are all strictly drug related. And he was sentenced to 12 years, which is outside of the recommended Virginia sentencing guidelines of 6 to 10 for this type of case. I wanted to share Brian's story to represent that, these aren't just numbers, and there are families attached to these individuals that are still being incarcerated for behavior that was responded to under a system of prohibition, right? And so the shifting attitude and really the impressive evolution of Virginia's legislature should really be, applied to cases like Brian to give his case a second look in light of legalization. There we go. And I wanted to also share that Virginia, some of you I know are attorneys and are probably already familiar with this code. Virginia's statutory framework for post-conviction relief is pretty limited. It's not in a million different places like we see in some states. And so in the Criminal Procedure Code in section 19.2-303, there is this way that courts are permitted in Virginia to modify sentences after a conviction. And this is, I'll speak more about a recent effort related to this in just a moment, but just a recommendation is for this body or whatever body is vetting resentencing language, that data collection on how this code is used and the outcomes that its use has resulted in around the state would be really informative for policy development around resentencing for cannabis. This is a picture of the sentencing guidelines with associated mandatory minimums of Virginia code related to marijuana. So the far right column lists some of the mandatory minimums that are associated with certain marijuana code violations in Virginia, and the column next to that, the second to left column.
Gracie, we can't really read the column the way it's presented. It's very small, so you may want to describe it rather than this slide.
Definitely. Yeah, and these slides have been provided to you all, so hopefully you'll be able to look at it later. It's totally okay if you're not able to read this tiny print. The point that I want to make here with this slide, and you'll definitely be able to view it later, is that many of these marijuana offenses, strictly marijuana offenses in Virginia, have very significant sentences, sentence ranges applied to them. Several of them have mandatory minimums, which I know for the most part have not been repealed in Virginia yet, applied to them. And several of them are actually life eligible. So the range runs all the way up to life, and for several of them, de facto life. So we're seeing 30, 40, 50, 60 years, the range is running up to. But thank you, Chair. I will definitely provide you with this slide to look at in more detail. I'm just bringing back the slide from before to remind you all of this three-tiered structure that we recommend, because we were able to access, with the support of the Virginia Department of Corrections, a bit of data, definitely not a comprehensive picture of who remains incarcerated in Virginia on marijuana-related offenses as related to each of these tiers that we recommend, but wanted to share with you today, as of the end of August, this data is what DOC has. So 10 individuals are still incarcerated in DOC facilities on a controlling marijuana offense. And from what we understand from the department, those were for distribution or transport of 5 pounds or more of marijuana. So this is what we would call that first tier of individuals that should get a very timely sentencing reconsideration for those sorts of strictly marijuana violations. So they are serving on nothing else except those controlling, or in Virginia, the Department of Corrections uses MSO, most serious offense, for those cases. We don't yet know how many individuals are on supervised release for those controlling marijuana offenses. For that second tier, we also don't have data yet, and I would encourage this body or other bodies vetting this sort of policy to ask DOC for comprehensive data on also how many individuals remain incarcerated or on supervised release solely due to an enhancement as a result of an ancillary or prior marijuana-related offense. Another way to think about this is individuals who are serving more time than they would have gotten had they not had a prior that was related to marijuana, or had they not had another charge attached to their current case that was related to marijuana. And in this third tier, I want to flag that this is conviction and not individual based data. So we don't have individual based data for how many individuals are serving on these different types. And I'm just going to skip forward for purposes of time. Again, you'll have these slides, but this is another data request from DOC that would be really helpful to really inform the policy development around resentencing, to really determine what people are serving for how long, and then that would inform how to craft the resentencing language. One thing that I just want to highlight here is that these numbers are not terribly high, and that's the good news. That should come as a relief, because we are not talking about contemplating a process that would be so cost prohibitive to the Commonwealth that it would be impossible to provide counsel and docket these cases and move them through a resentencing process. That's the good news. This is something that we really see as not a terribly heavy lift, but necessary to bring Virginia's criminal justice practice in line with the policy of repealed prohibition. The bad news is that these are still individuals like Brian. Even just the number 10, some of you may think that that's a very small number, but it's still 10 people like Brian who are separated from their family, from their children, for offenses that the court may view differently in light of prohibition's repeal. And I mentioned earlier, I wanted to share with the body, though I know many of you serve on judiciary and courts of justice, so you're probably already well familiar with the recent mandatory minimum repeal effort in Virginia, which I know has been existing for the past couple sessions. And most recently, the VCC endorsed that legislation to eliminate almost all mandatory minimum sentences and also significantly allow for retroactive resentencing. And so last year, last session, a couple pieces of legislation, SB 1443 by Edwards and HB 2331 by Mullen and Herring, would have actually, their initial iterations would have added to that existing sentence modification statute that I highlighted before in the criminal code 19.2-303. They would have added a retroactive resentencing process for individuals who were serving sentences that had then been repealed, had this passed, that were mandatory minimums. This to me is really significant because this passed 1443, at least passed the Senate. This was an effort that was vetted by I believe some of you and many others in the legislature as a sensible place for a resentencing process to add on to that sentencing reconsideration statute. You already have an existing framework. It would just be tacking on an eligibility scheme that contemplates individuals serving on sentences related to cannabis. So I think a lot of the work is already done. In other words, there's already a path kind of laid out for these individuals to have a statute in the criminal code that applies to them. I wanted to share the reenactment language that is related to resentencing. And if you are visually impaired, this slide does have different colors of highlighting, but I'll just go through them verbally, just to flag, as if you were to overlay the model policy components that I went over previously with the current contemplation of resentencing in Virginia for the reenactment bill. There's a few things that I would flag. First is in the yellow text, any person may file a motion. And so this is that non-automatic process that the individual may, rather than the state shall, or the Department of Corrections or courts shall identify those individuals. So I would flag that. In green is highlighted for a marijuana offense, and the subsequent clause describes a few disqualifiers, so types of cases that are disqualified from this relief. But for a marijuana offense is not a clear eligibility scheme. It would be very hard to implement this with any element of automation and avoiding misinterpretation. In the purple text is if it appears compatible with the public interest. This, I'm not aware if in other criminal code or precedent in Virginia, if this standard is very common and has in practice or in code an established precedent, but this, in our experience, is not a very clear standard. Compatibility with public interest could be phrased much more clearly, especially around those tiers where we would recommend enumerated lists of, the case factors that should be considered and the outcome that should be a result of whatever those case factors are. The blue highlighting is such court may reduce, suspend, or otherwise modify such person's sentence at any time. So reduce, suspend, or otherwise modify are the paths that this language is suggesting, of course. So this is definitely a great start, but again, would just encourage clear guidance for how the court should be expected on the basis of different types of cases to decide, should they suspend for certain types? Should they reduce for certain types? Which types? How should they modify? Should individuals be on supervision? Or should they be maxed out? Should they be released with no supervision? And then finally, the peach, maybe that's peach, tan highlighting, says the petitioner shall additionally file with the court a statement of indigency and a request for the appointment of counsel. Again, these are just a few more barriers that would be prohibitive to certain individuals that would otherwise be needing access to this relief. So we would encourage a proactive provision of counsel in this language. So the policy recommendations, this is just at a very high level. There's, of course, the devil's in the details, right? There's, of course, a lot of policy development to go on here to be really informed by data from that sentence reconsideration statute, if that can be accessed from DOC and perhaps parole and probation populations. Those data sets would be very informative. But at a high level, these are the policy recommendations based on our experience and the work that we do with resentencing policies that we would encourage this body to consider. That clear eligibility scheme, the state identification and initiation of the resentencing process, the provision of guidance and limited discretion for the process, proactive provision of counsel, those enforceable timelines that are clear and can be met, and that oversight and reporting about the process. So I am nearing the end here. So just to summarize, retroactive resentencing, not specific to cannabis or sentence reconsideration or modification. This is really an area in legal reform that we're seeing a lot of interest in over the past few years. It was not very commonly discussed a decade ago, and it is something that, in light of Supreme Court decisions and changing attitudes toward specifically drug offenses and other categorical types of offenses, we're seeing a lot of interest in states around the country to do this. We're also seeing it at the judicial, at the local level, with certain counties and district attorneys taking this upon themselves. So it's an exciting time for Virginia to be considering creating a categorical resentencing program in light of legalization. It is, of course, especially popular in the states just in the past year alone. Almost all of them have passed some level of limited resentencing with their legalization, omnibus bills or ballot initiatives. And finally, adopting a meaningful and accessible cannabis resentencing process will really, like I said, bring the practice of criminal justice policy, criminal justice in Virginia, and the incarcerated population in particular, in line with the policy of legalization that's been passed. So I will leave it there. I'm not sure, Chairman, if anyone has any questions. I'm not sure if I can see if there are any.
We will direct them to you. Thank you, Ms. Berger.
Thanks.
I do have a few questions just to start. You had given us some numbers of people facing who have been sentenced under certain charges in Virginia in part of your presentation. But did you have a total number of people who might be impacted by this in Virginia? We don't.
Okay. No, we don't. And we would definitely encourage a comprehensive Department of Corrections data request. So we have been in communication with them. They've been very helpful. There are certain data queries that are harder to do, and they said that they need to get in touch with other stakeholders. But within their data set, this is what was provided as of the end of August.
Okay. Well, we'll be following up on that. And one thing that would be helpful, I think, to me at least, would be you had looked at the reenactment language and suggested some areas that could be improved. I would welcome a draft from you of what you would like to see, not that it'll be what is adopted, but that would be helpful for us as we consider our future work.
Absolutely. We would welcome that. Absolutely.
Are there members of the subcommittee with questions for Ms. Berger? Okay. Thank you for really comprehensive overview of the challenge ahead in potential resentencing and adjustment to existing people who've been convicted of a marijuana-related offense. Very much appreciated. And
thank you so much for having us. We really appreciate it.
And we'll review your PowerPoint as well, go over it more carefully. Thank you. Okay, so we have, in addition to the presentations we had here today, we've got some policy discussions. The first area has to do with the legal access to cannabis. The JLARC report had recommended that we move up the timeline by 6 months for regulations so that retail sales could begin by January 1st of 2024, that licenses could be adopted in time for to stand up an adult use retail market. If there's no objections, that's what I intend to propose moving forward. But I don't know if there's any discussion on that particular piece. The next one, which is more controversial, is to possibly moving up the date for sales availability in Virginia if regulations could be stood up. And I think that's a pretty comprehensive, involved discussion. Are there people who have feelings on that or comment on it at this point? On seeing the date for legal sales, Delegate Krizak.
We talked about this. Thank you, Mr. Chairman. We talked about this at the last meeting as well. I think we can spend quite a lot of time here, but I would be interested in pursuing this in some way.
Okay, what I'm going to suggest is, rather than have the whole committee work on this today, is that we have a subcommittee come up with an outline of options for early sales, whether or not it is doable with the CCA, whether or not the pharmaceutical people could be used to do this, and if so, what role could there be given with diversity, equity, and inclusion or incubator requirements to see that equity applicants are not lost in that policy change. And I would also say, are there any possibilities, or would it be helpful to include any hemp manufacturers? Are there safeguards that could be taken, or would that work? So what I'm going to suggest is that we have a subcommittee to meet before our next meeting, and I would like to ask Delegate Scott to chair that and appoint Senator McPike, Delegate Krizak, and myself. It's a rather small subcommittee.
Mr. Chair.
Yes.
Mr. Chair. I didn't. May I suggest that, I know it's important to keep it small, but we have an expert among us.
Yes.
And if we could also add Delegate Adams to
Yeah, I think that would be great to have your expertise with us. So let's have that group, Delegate Scott, try and convene before our next meeting to come up with, this is what we recommend and how it might work, and then the whole committee can discuss it further and decide to move it forward or not. Additionally, there's the issue of seeds and clones. Currently, there's not a legal way to purchase seeds or clippings. So meaning those who seek to personally cultivate don't have a clear legal way to purchase supplies to do so. So do people have feelings on this subcommittee about allowing the pharmaceutical processors to sell clones and seeds starting next July, or comments on that? Yes, Delegate Herring.
I think that's a good idea.
Okay, so without objection, we can consider that moving forward as part of our reenactment next year. Then That's what I had on access to cannabis for that area of our discussion. Unless there are further questions, I want to bring up the regulator authority. Yes, Senator McPike. We'll be right back. Yeah. Yeah, Senator McPike pointed out that we didn't really have the subcommittee being very bipartisan. Delegate Morefield, is that something you have an interest in? Okay, so let's put Delegate Morefield in. Okay. Okay, a little larger, but better representative. Okay. And let's move on to the regulator authority. Now, in the legislation that passed last year, we capped, we codified caps on the number of licenses of various types. And the question is whether or not it's better to have a hard cap in the Code of Virginia or whether to allow the regulator any flexibility based on supply, demand, cost, and effect on the black market. Additionally, the limits on licenses could lead to prolonged litigation over licenses granted and incentivize attempted workarounds to social equity licenses, which could slow the initial rollout. Do people have any thoughts on allowing the Cannabis Control Authority to deal with the number of licenses granted rather than have that in the code? Are there any?
One thought, Mr. Chairman,
Yes.
is to roll out the licenses over a period of years so that we can pull back if we're doing it too quickly or too slowly, we can speed it up. But if I mean, not everybody's going to be ready anyway, but what if we did 50 licenses the first year and 50 the second, you know what I mean? Something of that nature where it wouldn't overwhelm the, I'm getting a no. But I mean, I'm just thinking out loud here, but it could be that, because I get worried about expanding it, you know, just not having any kind of a cap, but also we will learn as we go along, perhaps on the numbers. I'm just throwing that out.
We do have a cap de facto to start unless we take action as a subcommittee to decide to go another way.
Well, that's what I'm saying, if we decided to go another
Yeah.
way.
Mr.
Delegate
Chair,
Herring.
can you repeat the question again?
Sure. The question is whether or not the caps on number of licenses should be set in statute or whether we should let the Cannabis Control Authority have control of that using their expertise based on supply, demand, cost, and effect on the black market.
Mr. Chair,
Yes, Senator McClellan.
so I apologize. This is my first meeting, and I missed the JLARC meeting because I hadn't been appointed to this yet. But as I understand the question, this is around the bill as passed and presumably to be reenacted. It's the cap of 5 medical licensees, but I'm sorry, the medical licensees could have more licenses than the non-medical. And is your question whether we want to change the caps for both medical and non-medical? Or leave that to the?
I was referring in general to the overall number of licensees. The number that we did last year, I think we said that the medical people could have up to
6 locations.
Retail locations, the same number as their medical.
Right.
And then there was a numerical hard cap for the total number of licenses for both growing, processing, and retail.
Well, I guess, is this the appropriate time to discuss? So in the JLARC report, they noted that the law as proposed gives medical licensees a more substantial retail advantage over what they recommended in the initial JLARC study from last year. And I think it would be appropriate for this commission to discuss whether that's a good thing or a bad thing and give some guidance to the regulatory authority rather than just leaving it to them. Because I think there's a tension in our equity goals if we are giving medical licensees who are basically incumbents a competitive advantage. Now, granted,
Right.
there's a demand, so I just think we should give some guidance on how we want to handle that.
Currently, and you're right, this was brought up in the JLARC report, it was that they could each have up to 6 retail licenses, which the JLARC report pointed out could be as much as 7% of the authorized license market. And they had recommended that we consider, or that we could consider a lesser amount if we wanted them to have less of an advantage. If we were to go with early sales, I would think you would probably want to, some might want to stick with the scheme as it is, in that you'd want to do a better job of meeting potential demand.
I guess my point, Mr. Chair, is I think that's a policy decision better made by the legislators than by the regulating body.
Oh, in terms of the total number of caps?
Yes, because it will implicate how much of a competitive advantage will the medical providers have to meet existing demand? And again, that's a policy decision I think is better left to the legislators.
The number that the medical people could operate, or the total cap, or both?
Both.
Okay. Thank you, Senator.
Mr. Chairman, yeah, and I was thinking, I wasn't thinking of that. I was thinking more of the retail number, which I think we were talking about 400. Is that the number we have in the bill?
Is David May online?
Yeah, it's 400.
400.
And that's a number that's a number that went through the General Assembly last year and was no easy number to come, to all agree on. And I do kind of agree with Senator's point that really should be more of a statutory rather than a regulatory thing. So anyway.
Do we do that for ABC stores? Do we authorize them in the statute, or is that done by the ABC?
Mr. Chair, we do not. This is David May. We do not limit. It is a little bit different, obviously, with the alcohol, but as far as I know, we do not have a limit on the number of retail licenses granted.
Yeah, Mr. Chair.
Senator McClellan.
I mean, I think this is a different situation for a couple of reasons. And granted, I wasn't around when Prohibition ended, but my understanding is that to a certain extent, the market all began at the same time for everybody. Whereas here, we've already made a policy decision that whether we intended to or not, whether we wanted to be permanent or not, created market winners and losers. Or at least gave one market participant an advantage. So we, from the beginning, as a policy matter, put our finger on the scale for how the market was going to roll out. I think as we make decisions going forward, any decisions that will put the thumb on the scale of how the market will roll forward as far as, the strength of market participants should be made as a policy matter by the General Assembly through the legislative process, not by the regulator.
Okay. So from what Senator McClellan is saying, she prefers, I guess, to leave it the way we have it with a hard cap in the code. And then the other question is, did you want to revisit the medical
Mr. Chair,
cap for retail? Senator McPike.
I guess just to intervene, the additional pharmacy locations were already set aside under the separate law and separate provision is my recollection. The coupling, because remember you have the medical side with additional retail locations, and David May, you can jump in and correct me if I'm wrong, that was already set out under separate medical. Now we've sort of co-joined and allow the potential for the medical and recreational within those same locations. Is that accurate, Council May?
Senator, yeah, that would be accurate. Basically, the idea was they get to run one main shop, and then they have these 5 additional locations. So what we said was, you can have a license. Basically, if you meet the criteria, you can have a license for all of those current facilities. And we're also going to allow you to sell your pharmaceutical products and your retail marijuana out of those facilities, because we have other rules that prohibit, others from commingling your business.
Follow up, Mr. Chairman.
Yes, Senator McPike.
Thank you, David May, for the answer. So I think the question that Senator McClellan is sort of posing, I think, is now one of the predominant questions that's going to be chaired by Delegate Scott in terms of if there's early access to recreational, and I think that's one of the policy questions that's before this commission, as well as the future General Assembly considerations, is if we want to speed up some portion of access to recreational before 2024 or
Adult use.
Adult use 2025 or whatever the framework is going to be. What are the viable venues available to the General Assembly to do it within a context that builds in earlier access? And I think the considerations on the table is how do you ensure sort of market limitations? And that's certainly a great policy consideration to move forward. Do you ensure product diversity? Do you ensure social equity contributions and components to those programs as we move it forward? And I think that's something that we've got to wrestle with in the subcommittee to make sure we bring back strong recommendations.
Right.
Delegate Herring, did you have a?
I think he covered, because I think we
Okay.
touched on this last meeting about
Yeah.
a way to provide legal access. So, yeah, I think the subcommittee should work on something.
Okay, so,
Mr. Chair, may I add one little piece?
yes,
before you?
Delegate Scott.
I guess I was listening to Senator McClellan, and I think that's right on point. We got two different, paradigms set up with the medical marijuana and their licensing, which they would have had even if we had not passed adult use. And now we have a new paradigm with the adult use, and I think we have to take that into account. And I think that is a decision that we need to make. I was just looking when the previous presenter was talking about Montana. They had about 1 million people in the whole state of Montana, and they have somewhere over 300 dispensaries, if you can believe it. We have 8 million people, and we're talking about some smaller caps. So I think we ought to really take some considerations before we start talking about picking winners or losers, as you talked about before, Senator McClellan. So hopefully that's something that we can address. Thank you.
Thank you, Delegate. Okay. So then the other I brought up and suggested that the subcommittee look at it. There are two pieces of the hemp processor issue. One is whether or not hemp processors were allowed to get a license to deal with a higher grade of cannabis, whether or not they should be regulated by the Cannabis Control Authority rather than VDACs, since the Cannabis Control Authority will be regulating cannabis retail and eventually medical. Are there thoughts on that, having them all regulated by the same overseeing entity or keeping them with VDACs? Delegate Adams, did you have any comment?
Thank you, Mr. Chair. I think that's a good idea. I think there's a more holistic view of cannabis is the right way to go, and that way we can have more uniform discussions about how they interrelate and how they don't.
Okay, thank you. So unless there's objection, we can have an eye towards moving hemp processing regulation from VDACs to the CCA at the appropriate time. Then we move to license categories. The legislation requires the board to provide opportunities for small businesses to be vertically integrated, but the law doesn't state whether VCCA can create different classes of licenses within each license type, such as the size of the cultivators. And I want to suggest that we allow them to create classes of sub-licenses, whether it's for processing or smaller or larger. Without objection, we'll move in that direction. And then the potential solution. Oh, there was also in the House version of the bill, the what was it called? Micro licenses were introduced, and I wanted to suggest that we, instead of us defining what the micro licenses are, tell the Cannabis Control Authority that they could define what a micro license is based on the size of either retail footprint or the pounds processed or the acreage grown, to give them that charge rather than us try and kind of shoehorn that in without that expertise. Okay. Then is there any other further comment today about things that we need to look into based on the presentation on the resentencing policy? It's kind of a involved topic, but I don't know if there's other areas that I should be researching for future meetings. We'll get a list of what the how many people are incarcerated for what offenses as a starting point.
Mr. Chair, before you go over to criminal justice, on the regulatory side, one of the things that I was looking at, and I didn't know if we have this provision or not, but there are a lot of states that have set up alternative private sector testing and for these dispensaries for adult use, and I don't know if the state is going to do that exclusively or if that's something that we want to consider. That might be another way to bring some people into the market that may not have the capacity to cultivate, grow, retail, distribute, but just do testing. And so that's just something else that I wanted to throw out there. Maybe that's something for the Cannabis Control Authority to consider.
We have a state division of, what's it called, laboratory, a state lab that we were going to research with, talk to them about what they would want to handle versus having the VCCA address. Does that fall into what you're?
Yeah, I was trying to hopefully, I'm not a Republican yet, but I was trying to reduce some of the government
Private
oversight
sector.
and see if we can,
Well, let's,
and see if we can get the private sector more involved.
well, let's do this.
I guess I'll be on Twitter in a
I'm
few
going to
minutes.
I'm going to ask Henry Watkins from my office, who's been working with me on this. When we talk to the state lab, let's talk about if there are ways for private sector to be involved, and maybe we can check with NCSL or someone else if other states allow private sector to do testing. Okay. That runs
Mr.
through.
Chair, this is David May. If I may, I just wanted to note while you're on the topic, we do provide for marijuana testing facility licenses that people in the private industry can get. All the details of how that's going to work have not been fleshed out yet, but there will be opportunities for private companies to engage in testing through obtaining that license.
So that goes to your objective?
Never mind.
Mr. Chair, I have a question.
Yes, Delegate Adams.
To that end, if we are able to expand labs and things like that, where does that fall in terms of making sure that there's consistent oversight under whose guidance will that?
I would think that I'll have to find this out off the top of my head. I'm assuming that they get certified by a state entity like the state lab or the Cannabis Control Authority.
CCA will, but it's advised by the state lab as part of the advisory.
Yes, Senator McPike confirms that the state lab is involved in that.
For the private sector, though, I mean, so that
You
there's
can't
some.
just set up a private lab and say we're
Right, but in terms
testing,
of
someone
just
has to certify you.
the continuity, I guess, of how it's being tested specifically to meet, the standards for Virginia and the cannabis.
Would it be helpful to have the state, I don't know what it's called, the state lab come and speak to our next meeting, I think? Just so we can ask them some questions, and rather than, I think they'll have a more informed view than I would. Okay. That is the discussion agenda that we had for today. Are there other topics that members would like to bring up or see addressed at our next meeting?
Mr. Chair, I guess a question, and again, forgive me because I was not a member yet for the August meeting, but I understand that's where the JLARC report was presented, and there were some recommendations in that report.
Yes.
Has the commission already discussed those, or will that be part of what the subcommittees discuss?
We heard from JLARC, and we had a few questions for them. I met with JLARC again yesterday to go through those recommendations in depth, and I was planning on bringing forward a written list of ones that we might be able to adopt and see if people want to pull any out and not adopt them. But largely, I think we found agreement with a lot of them, if not most all.
Okay, thank you.
Okay. Right. There was one, Delegate Krizak reminds me that they were not unanimous, but most of them. Okay, are there any other topics people would like to see addressed today? If not, any further discussion, I will.
Mr. Chairman?
Yes.
I was just thinking, you talked about inviting the lab folks to come. at some point, we might want to also invite representatives from the other boards to talk to us too, and how they're doing the Cannabis Equity Reinvestment Board and the Cannabis Public Health Advisory Board. That might be down the road, but I'll just throw that out.
I think that's a good idea after they had a chance to
Yeah.
proceed on some of their work. Okay. So without, I do want to just say for the general public, though, if people have comments that they'd like to share with us, they can write to committeeoperations@senate.virginia.gov, and I would encourage you to use the word cannabis in your subject line so we can find your public comment. Again, that's committeeoperations, one word, @senate.virginia.gov. And also remind the public that there is a frequently asked questions website, cannabis.virginia.gov, with some of the information about the law that's passed to date. With that, we are adjourned. Mr. Chairman, yeah, Mr. Senator. You're taking in-person public comment today as well. Oh, I'm sorry. I missed that part of the agenda. Important part. Very important. We're going to take public comment. So people have comments and would like to share with us for 2 minutes. We'll, if you can line up the lectern and identify yourself, that would be great.
Hello, my name's Lennis Worth, and I've been coming to the General Assembly meetings for a very long time. In fact, my organization, Virginians Against Drug Violence, has been attending committee meetings since 1990. And I want to really say again that this is just great to have marijuana legalization. It's a big improvement for citizens of the state of Virginia. Now, I have one question. Would this be okay for me to ask a question? Is a dirty urine, as we used to say, still a parole violation?
I'm going to just say that for now, we're not really taking Q&A, but I will say that we have not discussed drug testing. That's not something that we've discussed.
Okay, but I think it's very important.
It is.
And so I just want to say right now that I think that should go, that it should no longer be something that people get put in prison as a parole violation after they've been sentenced and maybe their sentence has been deferred for whatever reason by the judge. If they have a marijuana is showing up in their urine, then they would go back to prison. I think that's obsolete at this point. And so I think that's the first thing I want to mention. The other thing is that I think it's really funny that the Cannabis Industry Authorities, CIA, I got a chuckle out of that. Okay. So I wanted to talk about streamlining the expungement process, but you all have done a pretty good discussion of that, and the last prisoner project, they seem to be on top of it. That just really needs to move forward very quickly. I think we all agree about that. And the drug testing of parolees for cannabis, that's got to go. So the Class 1 misdemeanor for paraphernalia sales, that still seems to be the law. And I think that needs to be fixed. So why can't I sell a glass pipe to somebody and say what you're going to use it for? Right now, the standard is you say it's tobacco. So that could be fixed. The mandatory minimum sentences still being in the laws and all the felonies. Honestly, if you have too much liquor in your warehouse, isn't that a fine rather than a criminal penalty? I mean, I think that these criminal penalties for disobeying the cannabis laws, maybe that has to be looked at and eliminated, because we should really be treating them as a legitimate business. And to have a felony for having too much of your product in your warehouse or whatever it is, this has got to be, we've got to look at it. There's a lot to do. And I really appreciate you all doing it. So thank you.
Thank you, Ms. Worth.
Yeah.
Mr. Bishop.
Yeah.
Mr. Chairman, members of the commission, my name is Dylan Bishop. I'm here representing the Cannabis Business Association of Virginia, or Cannabis VA for short. I appreciate all your diligent work here. I'd like to address two topics. The first is this commission's recommendation to regulate hemp processors under the Cannabis Control Authority. I think that's intuitive. Like Delegate Adams says, it's cannabis, it's the same plant. It makes sense to bring hemp also under the Cannabis Control Authority. But I would also suggest that while we're doing that, we also consider bringing the pharmaceutical processors under the Cannabis Control Authority under the same line of reasoning. If this agency is going to be the expert agency on cannabis, then they should regulate cannabis across the board. I do think it will make it more efficient to have all cannabis regulated under one roof instead of having it across multiple agencies and secretariats. My second point is on the date of sales for adult use market. I would like to share with this body that there are a handful of hemp processors that operate at a state-of-the-art level, and there are different benchmarks in order to measure that. The FDA has a set of guidelines called Good Manufacturing Practices. That's GMP, CGMP. There's also ISO certifications for pharmaceutical or nutritional products, and VDAX also has approval and inspections for commercial kitchens. I think that these hemp processors, they are often in rural areas. They're often state-owned. They have the infrastructure and expertise to help expedite this process, so we don't just have to rely on our pharmaceutical processors. There are benchmarks that are there that we can use to ensure that these hemp processors are operating at that same standard, and I look forward to participating in Delegate Scott's subcommittee and discussing that further. Thank you very much.
Thank you. Sir, welcome.
Thank you. Mr. Chairman, committee, I'm John Schenholzer. I'm known as the president and co-founder of the McShin Foundation, but when cannabis became legal, I started a Virginia Cannabis Education Association. I've attracted a lot of really smart people to this group, but one thing that came up with one of our members is the seed industry, and you touched on it briefly, allowing the medical cannabis companies to start producing and selling seed for legal growth. But some of these guys I'm talking to, they're like world-renowned experts on everything you need to know about cannabis, about seeds, about genetics, about engineer, and they operate in several states, and they've even went up against the federal government and won a RICO case against them in Colorado. But they don't think these committees are getting the best education they can get, especially in the seed area. And what they want to do, they want to roll out and start producing seed, but they can't do that because there's no caveat for that yet. So my purpose here today is to, bring you aware of this problem we have, and we want to solve it. So I guess I'll be contacting some because I have talked to a dozen senators and delegates, and they don't know anything about how the seed rollout's going to look. But the reason the seed is really important because you have a massive, the medical marijuana people rolling out consumer use seeds, and my people think that you need that healthy competition because they're not going to reduce the black market or the seed market right now. So Virginia has an opportunity to really roll out some good quality seed markets and do it right from the beginning, but it does involve in the policy decision-making process. So I want you to be aware of it. I know several of you. I know you're happy to see me up here. So you'll probably be some of the people I'll be contacting and see how we can, shape this so it's fair for everybody and you get the best product you can get.
Thank you. We'll look forward to your follow-up then. Thank you.
Thank you.
Please come forward.
Greetings to the chair and vice chair and the full commission. I'm Sasha Sproul. I'm the policy director with Marijuana Justice. We are focused on repealing the prohibition of marijuana and redressing the ongoing harms inflicted by the war on drugs by demanding resentencing and reparations for survivors of marijuana convictions. Earlier, our executive director, Chelsea Higgs-Wise, did some presentation on our policy proposals for resentencing through our Legalize It Right campaign. Marijuana Justice is also organizing a separate Coins Not Cuffs campaign effort to align Virginia's Cannabis Equity Reinvestment Fund with policies that would provide sustainable guaranteed income for those convicted of marijuana convictions in the Commonwealth. When the Commonwealth decided to legalize marijuana, equity was one of our main priorities. So we need to still collectively decide how the people in areas disproportionately impacted by the war on drugs will directly benefit from the Cannabis Equity Reinvestment Fund. Equity includes centering people who experience the most financial defects, ranging from denial to housing, employment, parental rights, education, and citizenship, due to the war on drugs. These survivors are still owed reparations for the harm done to them in the form of sustainable income. Fortunately, we can still put unconditioned, unrestricted direct cash payment transfers directly in the pockets of people who have experienced economic disenfranchisement from collateral consequences of the marijuana convictions. In wake of COVID-19 pandemic, the federal, state, and local governments passed legislation to provide cash relief to millions of individuals with CARES money. But they create a social safety net that perpetuates the same systemic barriers that prohibit vulnerable populations from getting relief. Reparations for survivors through guaranteed income would dismantle that social safety net by providing unconditioned, unrestricted, direct cash transfer payments. Guaranteed income is already happening. The Mayors of GI Project is a coalition of 25 Democratic mayors piloting guaranteed income proposals in their cities, including Richmond. By collecting data as we launch the statewide guaranteed program for those convicted of marijuana crimes, we will acknowledge the economic loss felt by communities disproportionately impacted by marijuana convictions. And Marijuana Justice is looking forward to working with this body, as well as the Cannabis Board, and with other legislators to directly target reparations for individuals with direct cash transfers for commercialized cannabis in Virginia. To the chair and the vice chair and the full commission, thank you for your time, and we're excited to work with you further.
Thank you. Welcome.
Hi, I just wanted to introduce myself. I'm Becky Hobden. I'm the founder and CEO of ECC Test Labs. And we are a cannabis testing lab in Ashland, Virginia. We started out in 2019 with hemp. And that's really where we got our ground to understanding what type of testing is needed in all cannabis industry. We moved from Blacksburg to Ashland in January of this year and started testing for the pharmaceutical processors at that point. We are registered with the Board of Pharmacy. That is the biggest extent of the licensing. It's not really a license, it's more of a registration. There is a requirement for quality to make sure there's consistency, and that's mostly done through the ISO 17025, which is not a small thing to get through if you're a lab. It requires a lot of validation, making sure that you're running quality samples, quality checks, you're training your employees. So there's a lot that is involved with that. But I do want to make sure that there is a place for the third-party independent testing labs, and that there is a place even for licensing. It's been a struggle with getting some of the clarity of what types of testing and some of the details of it, that I think from a higher picture, you don't see the need for as much detail when you're sitting there trying to run the samples. So I just appreciate that this is happening and that the labs are being considered, and would be happy to answer any questions now or at a future time, because it does seem like there's some gap in understanding or some education that can go along with understanding the needs of the testing lab and how they're a part of this industry.
Thank you. Thank you for being here today.
Good afternoon. My name is Philip Thompson. I'm the president of Cannabis Equity Consultants. First, I want to thank Senator McClellan for bringing up the fact that, the state has put their finger on the scale, and they've decided the winners. And the winners right now are the pharmaceutical and medical marijuana. Every inference that you have, you want to bend the knee toward the medical marijuana producers. You just said, hey, why don't we have them sell seeds when seeds are sold by numerous people, very good seeds, but the problem with that is that you put a process in place with no equity. And all of those companies are white-owned companies, and there was no equity in that process. So you've already put any minorities that want to get involved in this process behind the 8 ball. Secondarily, there's talk of having minorities and blacks to have to work underneath this process. Well, I represent a number of growers in different states, people that have grown and been doing this for a while, and they don't want to be sharecroppers to the medical marijuana people. And you should not make them sharecroppers to the medical marijuana. You've got to have an equity program. You decided to have this subgroup. You need to have a subgroup on equity. And you need to have that group go out to the community and talk to the people in the community. Having these meetings in the middle of the day when people can't get here is very difficult. You need to go to the community. You need to hear from people that have been impacted by this. You're doing great work on some of the expungement work, great work on some of the other areas dealing with minorities. But on the equity side, you're going to turn this business over to the majority group. And it's going to be very difficult for people to get in. Senator Ebony, I've sent you information on different states. They've all failed. So let's not fail here in Virginia. Let's do it the right way. Let's slow this down. Let's get some testimony from people that are out here and do this the right way, or else you've already picked the winners in this business. Thank you.
Thank you for your testimony.
Mr. Chairman.
Yes, Senator McClegg.
I think the last speaker hit on something that I think we're very aware of, and hopefully the challenge is before us and at the forefront, because every other state that has done this has, I think, failed in the social equity category. And, we need to hear from those who are out there who have experience to help get it right. I'm uneasy. I don't think we have it right now. And we've got a lot of work to do between now and January to try to figure out the right balance. I'm concerned about the amount of funding. We heard earlier, $6 million, it's a lot of money, but if you start to divide it up amongst potential equity applicants, it's not a lot of money. And we've got to figure out ways, if there's a way to bring private sector incentivized into this as well, that helps to balance to make sure, because we know that the financial institutions, there's very limited numbers that will participate, right? And so I think the earlier quote-unquote seed money, to really use the term here, really is needed. And if we're looking at the long-term, waiting on the tax revenue to come in, we're talking about either, number one, a very big fiscal ask in the next 2 years, or finding ways to look at a combination of general fund and private that has sort of the right balance of partnership and incentives involved. We have a lot of other funding priorities at the same time. And so I just want to put it out there, recognizing where the long-term funding stream is, and if we're coming out of the gate, we need to look at that right now to get it right. So thank you, Mr. Chair.
Thank you, Senator. Are there any other final thoughts from committee members today? Okay, with that, our meeting is adjourned for today.